How does a sexual assault judge alone trial, how does that operate? And not to be confused with a jury trial. I want to focus if you've elected to be tried by judge alone, for example, in the Superior Court, or you've made an election in the Ontario Court of Justice. So first of all, at the beginning of the day, you'll plead not guilty. You'll be there with your lawyer. And the Crown will usually start off by calling the complainant, we call them the victim in the criminal justice system, and they will testify examination in chief, which means the Crown will ask them who, what, where, when, why type questions, open-ended questions which don't suggest the answer. The defense will then cross-examine them, so I'll cross-examine them. My role as a defense counsel is to test their evidence, to see if it's credible, reliable, to try and make inroads into that to show they're not being accurate or truthful in their evidence. And that, in a sexual assault trial, sometimes that cross-examination can go on for a full day, sometimes even longer. I mean, it's a real art form to be able to do that. You're confronting the witness with any inconsistencies between what they've said today and their statement, improbabilities, motives to lie, in a piecemeal fashion, putting your client's version of events, and just generally trying to create a reasonable doubt. Again, it's not a science, but it's an art form that's learned over many years, and it takes a lot of planning and preparation, but also hands-on skills and spontaneity. You have a plan, you have areas and topics of crimination all mapped out, but sometimes the evidence will lead you to move away from that plan and you have to react. But you've got to cover all of your areas and do it in an efficient manner with a view to showing a reasonable doubt. The Crown is then entitled to re-examine them to clarify any points that arose during cross-examination. Typically in a sexual assault matter, they might call a police officer who attended with the person. Again, examination chief, cross-examination, re-examination. There may be other witnesses in what's called narrative, where maybe she disclosed it shortly after to someone who may be called, again, same process. I won't repeat it, but examination chief, cross-examination, re-examination. Any medical evidence, for example, there may have been a sexual assault evidence kit taken at the hospital, examination by a nurse or a doctor. They may testify, and your role, again, as defense counsel is to cross-examine them about all the facts surrounding that. And typically that's how one of those trials proceeds. The Crown will eventually close their case, but those are some of the typical witnesses to be called. Maybe there was also a witness in another room that the Crown called about what they heard or did not heard as well. And see, these cases can play out over many days sometimes. They're involved trials, they're complex, there's a lot of facts to go over, and the judge will make evidentiary rulings. The Crown might object to your questioning. The judge has to make rulings on the spot on the evidence where there's a legitimate question. There's really very tight evidence rules in Canada, any Commonwealth nation, of course, that need to be applied properly. There's proper questions and there's improper questions. As a defense counsel, you have to know those rules cold, and so does the Crown. I mean, to watch two good lawyers who really know the law well, there's minimal objections. When you have inexperienced lawyers, they don't know the law well, and there's objections all over the map, and the trial doesn't go so smoothly. At the end of the Crown's case, the prosecutor closes their case. That's my final witness. I'm closing my case for the Crown, Your Honor. As a defense counsel now, you need to make a decision in conjunction with your client about whether you are going to call evidence. The accused has a right to remain silent. In most sexual assault trials, the accused is called, invariably. There are situations where you might not do that. I won't get into it in any depth, but if you really feel that you, as a defense counsel, have already created a significant reasonable doubt or reasonable doubts, you've made tremendous inroads about the credibility and reliability of the complainant, you might choose not to call that witness, or a defense. You don't need to necessarily. That's a tough decision to make, because especially if your client's properly prepared, you've prepared them for hours, you know they're going to do a good job, and there's risk in not calling them. You know, there's risk, even if you think you've won the case, well, the judge might not view it that way. So my practice, there's been some rare cases where we made that decision, and it's my advice to the client. He or she, I represent women charged with sexual assault too, he or she makes that decision. We take a break to do that. But in most sexual assault trials that I do, and most experienced lawyers, the accused is called because we prepare them properly. Again, same process. I examine my client chief, cross-examination by the Crown, re-examination. There may be other evidence we called, like, for example, there may have been other witnesses in the home who didn't hear anything, there was no opportunity for the crime, or we're calling a private investigator about certain issues, layouts of room or photographs or things like that, or acoustics within a house that, the victim said that she was crying out. Well, no one heard it, and the acoustics are such that they would have, just as an example. So again, I'm saying, their typical serious sexual assault case involving sexual intercourse, for example, trials can take anywhere. I mean, it's rare to finish these in 5 days. I've seen 5, 7, sometimes 10 days. It's a lot of evidence, and it's not like on TV where it wraps up in a couple hours. It's very involved. There's hundreds of hours of preparation. There's sleepless, endless nights. And as a defense counsel, you're working through, I'm working through 2, 3 in the morning some nights, sometimes right through the night. That's just the way it is. It's a stressful business, and if you want to be successful, that's what you have to do. Now, if you've made the decision to call a defense and you then close your case, Your Honor, that completes the evidence for the defense, and I'm closing my case at this time. Now the judge will call upon the defense to make closing submissions. So you will focus your submissions on the facts that show reasonable doubt. And those submissions can take, I've been hour and a half, sometimes longer, up to 3 hours really sometimes, but I tend to be, sometimes even 45 minutes, but I tend to be an hour to 2 hours in my submissions depending on the case. We're presenting case law as well. There's cases, precedents that have to be shown and argued. The Crown attorney will then make their submissions. It may be shorter, it may be longer than mine, it depends on the case. And then I'm allowed to make reply submissions to issues that I couldn't have anticipated during my argument, but the Crown rose. Now the judge has to make, we've now finished our 5 or 7 or 10 day trial, and the judge has to make their judgment. Most judges, in fact, almost all really, if not all now in this day and age, will always put that over to consider all the evidence, to review it, and then make a decision and come back and make a judgment. And judgments can range from 1 to 2 hours about whether the accused is guilty or not guilty. So that, in a nutshell, is a simplified version of how the trial process works for a sexual assault judge alone trial. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.